SJC-11479, Commonwealth versus Ferreira.
Mr. Meth, when you're ready.
May it please the Court, Attorney James Matthew for Antonio Ferreira. I'd like to argue the first issue in my brief, which is that the judge abuses discretion when she denied my motion for a new trial and did so without a hearing. The judge found in a very brief memo that I hadn't established the burden to show that the evidence that I presented would have influenced the jury's conclusions or deliberations, and especially given what she said was the overwhelming evidence of guilt. Well, I would argue, I would say that finding was incorrect. The information presented in my motion for a new trial concerning Eric Koister was important because he was a supervisor. He testified at the trial. He was a supervisor of the other analysts. He was an important witness for the Commonwealth. He testified that he swabbed my client's hands at the police station, that he went through my client's pickup truck looking for evidence. He was at the scene of the crime with Stephanie Waite and directed her what to do. She took the fingernail clippings, and then he directed two other analysts to go to my client's apartment where they found some evidence. And those things that were found in my client's apartment and in his hands were the things that directly, the DNA evidence led to his conviction.
So tell me, give me a proffer as to what you say would be the inferences that a jury could draw if you had obtained all that you hoped to obtain.
Well, trial counsel, as he indicated in his affidavit with my motion, could have impeached Mr. Koister, as I said, who was the supervisor.
Right, you could have impeached him saying, you know, you failed these proficiency tests.
Right.
But help me understand how that is going to weaken, materially weaken the evidence that came in against your client.
Well, it weakens it because, as I stated, he was a supervisor, and the DNA evidence was the principal evidence that convicted him. I think there was, I would argue there wasn't overwhelming evidence of guilt, and I was going to get into that.
Didn't we just address this issue in the Sullivan case?
You did. I was going to bring up the Sullivan case.
Probably should, yeah.
Do you want me to address now why I think it's different than the Sullivan case?
Please.
Well, as you know, you don't apparently need to cite. In that case, this court, as you know, found that the evidence concerning Mr. Koister was admissible and that it was exculpatory, but didn't reverse the judgment because they said it wasn't prejudicial. But the big difference in that case, in my case, is that in Sullivan, the defendant testified at the trial, and he said, I apparently said I was at the scene of the crime. So the question was whether the extent of his involvement, not whether he was at the scene of the crime or not. Whereas in my case, my client never admitted anything, didn't testify at the trial.
But I thought in Sullivan, one of the key points was that Mr. Koister collected some evidence and then passed it along to the DNA section, and that was important evidence. And here, similarly, Mr. Koister swabbed your client's hands, and that was obviously important evidence, but that was passed along to a DNA.
It's similar in that regard.
Right, analyst. And we found it non-prejudicial in Sullivan.
But again, I think it's different than Sullivan in the respect that my client never admitted anything and didn't testify at the trial. So there was a question whether he committed the crime, whether he was at the scene of the crime. And another difference with Sullivan was that there was a Bowden defense in Sullivan, which attempted to weaken the investigation. In my case, there really wasn't. There was no Bowden instruction.
But doesn't that make it more important in Sullivan? Because in Sullivan, the Koister actually testified that he was this great chemist and he's passed all his proficiencies. And then there was a Bowden defense in Sullivan that the police were incompetent. And I thought we said in Sullivan, yeah, it was admissible because it would have contradicted Koister's testimony about how good of a chemist he was, and it would have furthered the Bowden defense. And here you don't have that. In Koister, in your case, doesn't testify to his credentials, just basically says, I was there, I was a supervisor, I swabbed their hands, and that was it.
In my case?
Yeah.
I
I
think
thought
there was
testimony
more-
was very, I thought Coiste's, I could be wrong, but I thought Coiste's testimony was very brief in your case.
I don't think it was very brief. I looked at it yesterday. I think there was 5 pages of,
But that, I
About-
guess it depends on how you define brief. But
right.
yeah.
There was 5 pages with his credentials and what, his education, background, training, and all that. So I wouldn't say it was that brief. Going back to, again, the judge's finding on my motion, she indicated there was overwhelming evidence of guilt, which I would dispute. There was evidence of a prior relationship between the parties here. There was no murder weapon found. There was no bloody clothing or any blood in my client's vehicles. Additionally, my client's roommates, particularly one who slept in the same room with him, never heard him leave the room or come back into the room at all that night. There were other people with motive in this case to commit the crime. And the DNA in Ms. Dos Santos' fingernails indicated there was 3 or 4 men's DNA in her fingernail clippings. So I think there was certainly, I would say there wasn't overwhelming evidence of guilt in this case.
Well, Judge Fahey was the trial judge and also the motion judge, and we have the witnesses who make observations of the car and of an individual with certain clothes on as well, right?
You're talking about the videos
Yeah.
of the area? Well, I think the videos showed a man.
And where he
Well,
went.
I didn't see the
Then
video.
he goes to a location that's where the defendant lives afterwards, the same car, right?
Well, there was evidence through, there was a couple different videos, I believe. The one where, right in the neighborhood, where they said there was a Nissan Murano that, I don't think they identified it absolutely as his car, but it was a similar make and model. And then you have the cameras from the circle there that showed a Nissan Murano going through. I don't think there was absolute proof that it was his car, but it was the same make and model.
Pretty inculpatory statements by the defendant, too, to the sister, right?
Inculpatory statements? I think they went both ways, really. I mean,
Didn't he say maybe the day before that he was going to kill her?
no, he didn't
No?
say that.
No?
No.
Okay.
I think they went both ways. There was certainly evidence that, he was sad that the relationship had ended. But on the other hand, there was other evidence that he was in fine spirits the day before. And in fact, there were phone calls. I believe the evidence was that there were phone calls from Ms. Dos Santos to my client like the day before. So there was, as I said, I think the evidence went both ways as to whether he was that upset or he wasn't about the relationship ending. I think that my motion for new trial raises a substantial issue. It was a failure to turn over exculpatory evidence. I had affidavits in there, one from Dr. Ladd, who indicated that the lab would have known prior to the date of the trial that Mr. Koister had failed the proficiency test.
Could you explain that for me, please? The timing of the trial and the timing of the proficiency test and when the report was written and how
Right.
whether it was known or unknown?
What it was, the due dates on the 3 tests were prior to the trial date.
On the proficiency test?
Right.
Okay.
In fact, one of them, I just looked at it again, it was like one was 3 months before, one was 6 months before, the other was about a year, actually over a year before. But the question was when, on the line where it says graded date, it's actually May 2012, which is 2 months
So
after the trial.
we have the witness taking proficiency tests, then we have your trial, then we have him being graded on the proficiency test.
Well, I would argue that they weren't graded like a year, I think it was, the graded by date was much after the due date.
So I'm trying to figure out whether this evidence existed prior to your
Right.
trial and could have been used by a defense counsel.
Right. Well, I tried to argue, obviously, in my motion for trial that it was available and should have been produced, but even if it wasn't, I argued it's newly discovered evidence, which is the same standard,
Right.
really, the same legal standard. So I think it's not critical that I show that it was before the trial.
Well, yeah, one would have been arguably a discovery violation, the other one is in trial, right? I understand, thank you.
Page 19 of the Commonwealth's brief with a cite to the transcript. Shortly before the murder, he had threatened to kill her and then kill himself.
But is that something that's a quote, or is that just?
Yeah, well, it's going, citing to the transcript.
I don't
Well,
recall
we'll
who
ask the
said that or
prosecutor,
how.
it's in her brief.
I don't recall what witness, I don't think there was a witness that testified to that.
We'll ask the prosecutor.
Can you,
Oh, is it the motion to suppress? That's,
Well, there's a motion, it's a transcript reference, MTR. I don't know if that's motion, transcript.
well, I think it's,
she agrees with me that it wasn't testified to at the trial.
right, well, page
Thank you.
10, there's no other reference, but it's maybe an inference
I
from
think-
the statement of, give a message to her and tell her that she's dealing with a person who has no life, so I
Right,
don't know.
that was definitely-
That he said.
Right, that was definitely testified to.
And the meaning of that, I guess, is debatable. Tell me about, was there an objection to the admission of Anna's rant and of him hanging up the phone?
Oh, right, that was, you're talking about the telephone conversation.
Yes.
Right.
That's the admission by silence issue,
Right,
the
right.
adoptive admission issue.
There was, trial counsel did object to the entire conversation, yes.
Did he object specifically
well-
to the admission by silence,
I don't
or
think
did he object only to the entirety of the conversation?
Yeah, I think it was the latter, Judge. I think he objected to the entire conversation as being an opinion by Anna Paula, whereas I kind of took it a step further. And there was an instruction, I believe, right after by the judge. Yeah, there was an instruction right after that by the judge to adoptive admission, and then at the final instructions, right?
As to adoptive admission, the judge did
Right.
instruct on that topic?
Right.
Okay, thank
So
you.
so the judge understood that that she was allowing it in as an adoptive admission? There was, at least that issue was raised enough for the judge to recognize that that was the
Right.
claim?
Because the judge instructed immediately after that.
Do you know
on
if the
adoptive-
judge instructed, because I'm not sure if I got this, that in addition to being able to hear and understand and have an opportunity to respond, another foundation is that you'd expect that a person in a similar position would respond. I didn't see anything, at least in the briefs, that said that was part of the instruction. Do you know if it was?
I can't recall the exact instruction. no,
Okay.
no. So my argument on that, obviously, was that the threat to my client was immediately after she said, "You killed my sister." So when somebody threatens you by saying, "I'm going to kill you, I'm going to kill your family and your children," then I don't think you'd be expected to respond to that. I think you'd either hang up the phone, or if it was in person, you would just walk away or run away, basically. So I don't think that met that test in that sense. And then the other part of that is, just prior to that, when Anna Paula said, "Where's my sister?" and my client said, I don't know, I haven't seen her for a week, and the judge determined that was a lie and therefore instructed the jury on consciousness of guilt. Well, I think it's kind of splitting hairs, because Anna Paula's testimony was that my client saw Mr. Santos like 3 days before. So, whether it was 3 days or 7 days, I don't think makes it a blatant lie. I don't think it was, an instruction on consciousness of guilt was really warranted in that situation.
Was the instruction given immediately after that testimony on consciousness of guilt, or was it given at the end of the case?
At the end of the case, I did check that, yeah. It's the end of the case.
And was this the only statement he made that arguably could be a consciousness of guilt statement? That the jury would focus on that?
I believe so. Another issue that I wanted to touch on was the second issue in my brief, which is really related to the first issue, was that the judge abused his discretion denying my motion for post-conviction discovery concerning Mr. Koister. I was looking for possibly employment records or reviews or audits to possibly indicate whether Mr. Koister had other issues that were causing him to fail these tests. Again, the judge basically said the same thing in denying that motion, that Koister had a limited role and I didn't meet my burden. But
Just to be clear, the alleged I'm not sure it's misconduct, the alleged deficiencies of Mr. Koister is that he failed a blood splatter test, which was basically failed to demonstrate that he knew enough about blood splatter to testify to it.
And trace evidence, there was a fail on a trace evidence test.
Or the
Trace evidence?
trace evidence, okay, but was there, blood splatter was not at issue in this case?
No,
And
it
was,
wasn't.
was trace evidence at issue in this case?
I would say so. There was, they swabbed his hands.
And in terms of his failing the test, was it a failure in terms of the gathering of trace evidence, or was it a failure with regard to the interpretation or analysis of trace evidence?
I don't exactly recall that.
Isn't there a difference between trace evidence, as we understand it, and taking a swab from somebody, an exemplar? Isn't trace evidence, you look at the sweatshirt and you see if there's anything, and then an exemplar is a buccal swab, a swab of the hands, et cetera? Are those two different things?
I don't really think so, Judge. And again, he also went into my client's pickup truck to look for evidence. Didn't find anything in the pickup truck.
Well, my memory was that after the crash, he walked by it, took a quick look, and then other people searched the pickup truck because it was towed, right?
No, I believe he searched, I recollection, he searched the pickup truck based on a search warrant.
I thought it was towed and somebody else did, but I could be wrong.
Yeah.
But there's nothing arguably exculpatory about what he would have found in the, so it's hard to argue he would have found something that would have indicated that he didn't do it in the pickup truck.
That's correct, Judge. I'd like to move to the fifth issue in my brief, which is the judge abused his discretion by allowing the DA to read a witness's grand jury testimony, his prior recorded testimony. The DA asked the witness, Mr. Ferreira, if he recalled his grand jury testimony, and he said that he didn't. And then the judge allowed the prosecutor to read 4 questions and answers from his grand jury testimony.
Was that under feigned memory?
Pardon me?
What was the basis of the admission of it for substantive evidence?
Because he apparently didn't remember his grand jury testimony.
Was it memory refreshed? Was it substantive? What?
The judge let it in as the prior recorded testimony, so
Okay.
it went in substantive. Yeah.
So the judge didn't find that the witness was feigning memory loss, from
No,
what I
I
understood.
don't believe she found that.
So, and did it come in as prior recorded testimony or as recorded recollection?
Well, I believe the terminology used there was prior recorded testimony.
And it's not that. Recorded testimony is of unavailability of the out-of-court declarant and similar motive and opportunity to cross-examine in a different circumstance. So
Right.
what we know it's not past recollection recorded, and we know it's not former testimony exception. So it has to be, as Justice Budd and Casiano just indicated, prior inconsistent statements, the inconsistency being feigning a lack of memory. Was there ever a finding by Judge Fahey of a feigning of a lack of memory?
No, I don't believe so, no. And that evidence was important because what he read from his grand jury testimony was a conversation he had with my client where he made these derogatory statements towards Mr. Dos Santos, which the Commonwealth used to show his disdain for her and possibly a motivation to commit the crime. So I think that was pretty important testimony that came in and it shouldn't have come in.
Was it argued as impeachment?
Pardon me?
Was it argued as impeachment evidence or instructed that it was impeachment?
I don't believe so, Your Honor.
So why is it not recorded recollection, since he apparently remembered it at the time and no longer remembers it?
Well, I believe it also doesn't come in as, I have it down, past recollection recorded because there's like 4 prerequisites I argued in my brief and really only one was established that he didn't remember. The other ones were never asked or, so I would argue it wasn't admissible on that basis.
So are you saying because those questions were not asked, or because we cannot infer the answers from other parts of the testimony?
That would be correct. I don't know how much time I have left, but
48 seconds. But who's counting?
I guess you're counting. Well, in that case, Judge, I will, if there's no further questions, I'd ask this court to reverse the judgment. Thank you.
Ms. Spade?
Good morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. If I can just, because I've had the luxury of sitting here and being able to dig through the transcripts without you asking me questions, there was in the contemporaneous and the final instruction on the admission by silence, Judge Fahey did say, sometimes when a direct accusation against a person is made to his face, you might naturally expect him to deny or correct it, and you have to find that it would have been natural. You also have to find that he heard and understood the accusation. That instruction was correct. It's not challenged here. There was not a consciousness of guilt instruction given contemporaneously, but in the final instruction, it's clear that she's referring to the untruth about the defendant saying he had not seen her for a week, when in fact it was less than 3 days. He saw her at the club on the night of September 29th, and this phone call took place on the morning, late morning, I think, of October 2nd.
Can you explain the legal theory by which the grand jury questions that were just referenced were asked and allowed in?
There's a little, this wasn't beautiful. There's a little imprecision in how this was argued and how it came in. It's true that both ADA Lynch and Justice Fahey used the phrase prior recorded. I think they said prior recorded testimony, and the defense counsel said past recollection recorded. It is neither of those. It is, in fact, testimony admitted under Commonwealth v. Day and Commonwealth v. Berrio, and proposed mass rule of evidence 801D1A, which is inconsistent.
And
Right,
I think you argued in your brief or pointed out that they cited, the prosecutor argued Day.
She clearly cited the correct cases. This was a highly experienced veteran judge who
But
was
where-
presumed to know the law.
So where did she- yeah,
She did not
the
make an
feign-
explicit finding that he was feigning lack
Where's
of
the
memory.
implicit finding?
I think it's in his, and again, she was there and could see the witness who looks at the grand jury testimony and says, well, if it's there, I must have said it, but I don't remember. So I think
But-
the fact that she admitted the testimony
Shows
suggests
that she implicitly found that he
found the
feigned-
requirements were met.
Okay.
And that's the Scenero case that puts feigned lack of memory in the category of makes the testimony inconsistent. But even if this court were to find that, because all the requirements were not explicitly, all the boxes weren't explicitly checked, this was a statement purportedly made by the defendant 3 months before the murder, in which he calls the victim a whore and a lowlife. His feelings for her and it were well known, that he was angry about the breakup, that he didn't want to break up, that he wanted her back. And in the context of the case as a whole, it really is not, it's far from the most.
Is there other evidence of hostility towards the victim?
Well, there is the statement, I think the night before the murder, when he tells the sister, tell your sister she's dealing with someone who has no life, which is vaguely threatening. And by the way, the statement about that he had threatened to kill her and or himself, the victim's friend, Miss Alvarenga, I'm blanking on her first name, she testified at trial and spoke with the police. When she spoke with the police, she told them that a day or two before the murder, the victim had said to her that the defendant had said he would kill her or himself, or he didn't know whether he would kill her or himself, or he was going to kill her and himself. I think it comes in slightly different ways and in different versions. She did not repeat that testimony at trial, but that's where that came from. It's also in the affidavit supporting the search warrant application that her friend had said that the victim had said. So that's where that comes from, and it threw me when I was preparing too. I was like, wait a minute, why isn't this in our statement of facts. So the bizarre behavior with the sister in the days before the murder, telling her that he had all these drugs and he was going to take them and he had no life. She had said, "We'll find you another girlfriend." He said, "I don't want another girlfriend. I want Shayla." You know, it's not a confession. It's not anything that proves an element of the offense. It merely goes to his state of mind, so that even if this court were to find that it should not have come in, or that the findings should have been more complete, it certainly does not warrant reversal of the conviction. Where I think Judge Fahey was certainly well within her rights to call the evidence overwhelming. It's mostly circumstantial, but there is an awful lot of it.
What did Mr. Silvera, he did say that the defendant had characterized the victim as a lowlife?
Whore and a lowlife.
No, that's what he said in the grand jury. But
Yes.
But at trial,
Did he say lowlife at trial?
I thought he said something at trial, and then, which was,
He may have said, and he became very evasive.
doesn't sound, I mean, I haven't looked at it, but it didn't sound that evasive, frankly.
It's volume 6 of the transcript. That's the grand jury testimony. Well, I don't want to take the court's time to. At first, he would say that the relationship was good. There was one time where he said that he had to forget her, but then he was with her again. At the time, I don't remember the exact words that he said correctly, and that's as far as it goes. I don't. Low life comes in the discussions, but I don't think it's in his testimony. I don't think it's in Silvero's actual testimony.
I see, okay.
But he.
Can you speak to us as to why this is an admission by silence under the circumstances? And why her rant comes in, her accusation that I think he killed my sister?
I think, first of all, the jury were instructed contemporaneously, and I can't remember whether it's in the final charge or not, but contemporaneously they were instructed that they were to draw no inference from her, that it was clear that she was not there. She has never said she was there. She never said she has direct knowledge, that her opinion is just that, an opinion. So they actually were instructed on the proper use of that part of it, that it was of use to them for his reaction to it.
Did Judge Fahey instruct on the foundation for the adoptive mission, so?
That they must find that he heard and understood, and that it would have been natural for someone to deny?
Had an opportunity to hear and natural for somebody to deny?
Yes, that was the correct, and it's the correctness of that instruction is not challenged.
Okay.
And the defendant was able actually to sort of get in under this a bit in his cross-examination of Sergeant Hurley, who was the one who had gone with the officers to talk to Ana Paula because he said he spoke Brazilian Portuguese and he went along as the interpreter. And in cross-examining him, the defendant was able to get him to say that the first time Ana Paula told him about this conversation, she told him that the defendant had denied it. And so that was in, and they argued that in closing, and so that was actually, they got a chance to undermine the fact of the silence. Ana Paula, in her own testimony, is very dismissive. She says, "Oh, he doesn't really speak Portuguese. I couldn't understand a word he was saying. He really wasn't very helpful." But this was all in the heard and understand and denied or didn't deny. It was all out there in front of the jury, and they were instructed that it was up to them to decide what to do with it and what they needed to find to in order to consider it against the defendant. Right. So that was all fully before the jury. Okay,
because admissions by silence, even before, when someone's not in custody, is a big deal, because we're inculpating the defendant from something that the defendant didn't say. And our case law talks about, it has to be clear that somebody would respond and that you have to really admit these with caution, all of those concerns?
I've read all those cases, and I know that the court is very, has concerns about admissions by silence, and I think rightly so. And I'm not saying this is the textbook case of admission by silence. I think it could be taken either way. But I think that's a reason to let the jury, properly instructed in the use of the evidence, decide whether it is something that would have been natural for him to deny or whether it would have been natural for him to respond in any way.
Well, she not only said, "You killed my sister," she said, "I'm going to kill you and all your family." Oh, is he expected to respond to that?
I think they were friends, and he was friends with Ana Paula, for the entire 6 months after the victim broke up with him. And I think it's not irrational to say, when you are talking to, your friend whose sister's just been killed and she's understandably distraught, and she says, "I think you did it and I'm going to kill you," that they're friends, and that it would be natural for him to say, "No, wait, I can see you're upset, but I didn't do this." I think that's a very reasonable finding. It's well within Justice Fahey's discretion. It is certainly within as we say now, within the range of acceptable alternatives for her to have admitted that and then let the jury decide whether it showed whether it was an admission or not. As for Eric Kester, it's not completely clear from the record how much was known at the time of his trial testimony. It is, and this is, I'm looking at record appendix pages, right around pages 210, 212. There's a sort of a timeline of his unsatisfactory test results. One thing that is clear is that as of the end of February in 2012, he had satisfactory results on those tests. Sometime in March, both tests, the trace evidence recovery and the blood spatter analysis, were sent back for reevaluation. And sometime after that, he was informed that that the pass had been changed to a fail, basically.
After trial?
This is the part that's not crystal clear to me. One of the memos, and this is record 212, says around the time of March 9th, which would have been before his trial testimony, Ms. Sullivan and I contacted Mr. Kester and informed him that the satisfactory result had been rescinded, but the date on the actual exam form, both exam forms are, one is April 30th and one is May 4th. So that's after his trial testimony. Now, if at the time of his testimony he knew that he had failed the tests, yes, that would be exculpatory, and that would be probably a Brady violation if he didn't tell us and we didn't tell defense counsel. And this distinguishes the case from Sullivan, by the way. Sullivan was tried sometime after this case when Kester definitely knew that he had failed the tests. So it's a little fuzzy here.
Shouldn't we look at it in the light most favorable to the defendant, that there's evidence here that he did know? I mean, let's say he did know.
Yeah.
Does it make a difference in your analysis?
No, actually it doesn't, because whether it's a Brady violation or newly discovered evidence, the defendant concedes he made only a general request for exculpatory information. So the standard is virtually the same. Does it cast real doubt on the justice of the conviction? And here I don't think the case is distinguishable from Sullivan. Kester's role was virtually the same. He directed other chemists how to collect the evidence. He did one swab of the defendant's hands. Blood spatter analysis was of no relevance whatsoever. He did no testing. He did no analysis of results. And the language of the Sullivan case here, I think, from page 383 is pertinent here. The actual DNA testing in which Kester had no direct role likely did the most damage to the defendant's case. He had absolutely no role. He wasn't even in the building when the most damning evidence forensic evidence was collected, and that's the drop of blood
That's
on
on
the
the
defendant's sneaker.
That's on the sneakers, and.
Yeah, and that-
he-
that-
He swabbed their hands, and there was some evidence on the hands, right?
There was some evidence, there was occult blood on the backs of the hands. Kester swabbed them, and there was the victim, I can't remember whether it was included or could not be excluded, where on that range, but it was
But it
a,
wasn't- but it
it was a
wasn't-
very weak result.
But it wasn't the bajillions you get like they did on the
The
sneakers.
random match probabilities for that test was, on one hand, it was in the 3 digits, and on the other hand, it was in 2 digits.
Then
So
they go-
it's a very
Then
weak
Kess
result.
has nothing to do with the collection of the sneakers and the analysis of the
Absolutely nothing. He
sneakers.
wasn't even there when that
Which
sneaker
leads
was.
to her
He
blood.
didn't touch the sneakers, and that result was in the quintillions and septillions.
And as Justice Garziano mentioned earlier in Sullivan, where there was no substantial likelihood, but there was a Bowden defense here, and is there a Bowden defense here?
Well, not as regards the DNA evidence.
Yeah.
There was, certainly the theory of the defense was that the police had rushed to judgment based on the sister's angry comment.
Okay. So
And
no
there
forensic.
was all sorts of questions about, Officer Hurley's proficiency in Portuguese and whether any of these communications really were accurate.
Anything on Bowden as it had to do with forensics?
No. But again, where he failed in trace evidence collection, and the nature of the test was, it's sort of I don't know if it's like a box of stuff that you look at or if it's a picture, and there was a hair that he missed. And if the argument is, if he'd done better, he would have found more evidence, I don't see how that helps the defendant.
Not a great argument for you, though. I mean, basically, we have
Given that there
we have an incompetent chemist, but he's incompetent because he doesn't find stuff.
He didn't.
Because it could be exculpatory, so let's not go there.
Okay, we won't go there. But the fact is, this was entirely impeachment evidence, and it could only have been
But
used to
we
impeach
did say in
Kester.
Sullivan that A, it was exculpatory, and B, it was admissible, right?
Yes.
So now the issue is impact on the jury.
But this court also has said, I don't know how many times, that new evidence that goes only to impeachment it's almost never a reason to upset a verdict. And the trial counsel's assertion in its affidavit that he would have, quote, attacked all the DNA evidence, and he doesn't say how he would have done that when he was doing it through the qualifications of somebody who did no testing, no comparison, and only collected one sample. I don't see how you can mount a Bowden defense against the DNA evidence when the witness that you would have attacked it through didn't have anything to do with the most inculpatory evidence.
Now, was he involved in the error in probability with regard to the YSTR?
I don't think that it wasn't his error. It was a method, a calculation method that had been used that was then revised, and under the new method, the random match probabilities went down. But I
Went down from like 1 in 250 as opposed to 1 in 250,000.
But again, this was something that only affected the fingernail swabs, because that was the only YSTR that we
So
we had.
the view is that would not have affected the jury's
No.
deliberations because of the latent blood because of the blood in the sneaker, largely? Is that
The blood on the sneaker was the most compelling forensic evidence we had, and it was the one piece of evidence that could not be explained away by saying they had a relationship. And that was what they argued about the DNA under the fingernails. They said, look, this is a mixture of at least 3 men, and by the way, they had a relationship. They had a sexual relationship. It's not surprising that there should still be some DNA of his under her fingernails. So changing that, and even, it's simply not, this is simply not a case like Cowles or Cameron, where you get a new result that excludes the defendant. He's still included here.
Right. So, but why do you say it's overwhelming evidence? I mean, yes, you have motive, and you have that statement the day before.
You have the blood on the
You've got the
sneaker, and you have video that tracks him virtually from his front door to virtually her front door, or the back door, I guess, was where he found her. And
Tracks
her.
him or
the-
tracks the Murano?
It tracks a car that is consistent with his at 1 o'clock on a Friday morning. So not at rush hour when there are millions of silver Muranos around. But it follows him. You've got three surveillance cameras, at least three. I think there might even have been 4 because there were 2 on the traffic circle. And it follows that car right just before the murder, going from his house to her house. And her building was right off that traffic circle. There were maps and evidence, and I don't think it's even a block away. And then back the other way immediately after. And you have his, and that's powerful. The DNA is powerful. His bizarre behavior in the days leading up to the murder support that. Overwhelming was Judge Fahey's word. I was not at the trial, she was. And so I don't, even if this court might have used a different word, you can't say this was a weak case. And if there are no further questions, I would simply add that the defendant offers really nothing in the way of argument to support or request to reduce the verdict under Section 33E. There are no special circumstances here. He chose to follow her to her house, stab her 31 times on the back step of her house, and leave her to die. And this court should uphold the jury's verdict in this case.
All right, thank you. We'll
Thank
take our
you.
morning break.